Hi, welcome back. Now that we have discussed all areas of an offer, let us move towards the part of acceptance. So as we discussed in our previous slides, in order to come into a formal legal contract, there should be an offer by an offerer, and definitely there should be an acceptance from the offeree. And without an acceptance, there will be no formal contract. The next few slides we will be discussing in order to understand what are the important aspects within this framework of acceptance. So acceptance is something that should be done from the offeree's part. So by accepting an offer that has been made by an offerer, the offeree will agree to be bound by all the terms and conditions of the offer. So as we discussed before, there could be so many confusing statements within an offer. Even though the offerer might think that their statements are very clear, specific and precise, from an offeree point of view, those statements could be sometimes confusing. And that's why there will be a discussion that will happen between the two parties in order to clarify any confusing statements. And after the offeree comes to a total understanding only, the offeree will be agreeing or accepting that particular offer. So by agreeing to that offer, he will be bound to all the terms and conditions which has been stated in the final offer. Also, to be legally binding, an acceptance should fulfill three basic rules. And those three rules will be: the acceptance must be a mirror image of the offer. There cannot be any differentiations. The offer and the acceptance should be exactly the same. The second one would be the acceptance should be a firm one. There cannot be any conditions. There cannot be any variations. If there are any conditions, those should be taken within the negotiation or during the negotiation stage, and the final acceptance should be firm. And the last rule will be the most important, that acceptance must be communicated to the offerer on time, because as we discussed before, there will be a time validity, and during this time the offeree should make a decision, and if accepted should be communicated to the offerer during this time frame. So rule number one must be a mirror image of the offer, meaning the acceptance must be for all the terms of the offer and there cannot be any variations. Also, there cannot be any new terms that can be introduced, as this will constitute a counter offer which will reject the original offer that has been made, meaning the offer and the acceptance must be based on the same conditions. In a situation that the offeree offers a counter offer, then it is considered to be a new offer which the offerer either can accept or reject. If the offerer rejects the counter proposal or the counter offer, the offeree cannot then accept the original offer, as it has been already destroyed by the counter offer that has been made. So in conclusion, once an alternative or a counter offer has been made, it may not be possible to return to the original offer as it has been rejected. Rule number two, acceptance must be firm. So conditional acceptance is not legally binding. So when an offeree is accepting something, they should be very firm on what they are accepting. Also, there could be any agreement that could be subject to contract. Is not generally binding in terms of the legal framework, but the intention of the parties is very important, and sometimes exceptionally the court might decide that despite its provincial appearance, a valid acceptance can be taken place. So, in summary, on rule number 2, when you are accepting something, the offeree should be firm on the decision. Rule number 3, acceptance must be communicated. So, when the offeree accepts something, that communication has to happen back to the offerer. So, that communication should be effectively done only by an authorized person. Look at the example that I have quoted. Powell was informed that his job application has been successful by a member of the appointment panel, which then decided to give the job to another candidate. The reason being the member of the panel was not authorized to communicate to Powell. So, there should be an authorized person always communicating the acceptance back to the offerer. And offerer also should be very careful when he's receiving an acceptance to cross-check whether the communicator is authorized or not. There are few methods of communication on how an acceptance could be communicated by an offeree to an offerer. It could be through writing, it could be through a speech, or it could be even through a conduct. Whatever the method would be, it should be by a reasonable way and commonly in the same form as the offer was made. So as an example, if a certain offer was made through writing, then as a general practice, even the acceptance would be communicated through writing. Also, any communication to be complete and effective only when it reaches the offerer or the offerer's place of business. So until the communication reaches the offerer, that method will not be completed or effective. Just look at the example which I have quoted. It was a court case between Warner Music and Confetti Records. Confetti Records, they have sent an invoice with a music track, and it was deemed to be an offer to sell the material to Warner Brothers or Warner Music to be marketed. By producing a music album containing that particular track, Warner accepted the offer. So, both the offeree and the offerer needs to have a clear understanding on these communication methods and how they will become effective. In today's business world, email has become a powerful tool, a very powerful communication tool. We all know that there are so many offers that might be communicated by an offerer through an email. And after going through all the information within that offer and any discussions if needed, the offeree can accept and communicate the same back to the offerer through an email. So in today's business world and in the legal framework, courts are accepting emails as a valid mean of communication. But there are few things also that we might have to consider when looking at sending an acceptance through email. And they could be We have noticed that there could be so many delays because of technology, even though the offeree has sent an email of acceptance. Until that email reaches the email account or the email Outlook box of the offerer, the communication is not completed. So unlike those days when acceptance were done in writing through formal letters or through speech, when any communication is happening through emails, there could be some barriers which are occurring through technology. So these could open up some concerns if there are any gaps that has happened within the communication. But in a nutshell, in today's world, within the legal framework, email is accepted, but as an advice, the offeree or the offerer should be extra careful when they are dealing with emails. So they might have to have a second way of cross-checking whether the respective communication have reached the other party. Being silent. In today's business world, there is a general acceptance saying after an offer, if the offer is silent, then it means it has been accepted. But from a legal perspective, it's not. From a legal perspective, silence is not considered to be a valid acceptance. I have quoted an example which has been a famous case study. In this case study, an uncle has offered to buy a horse from his nephew on the basis that if the uncle hear nothing more, that it means that he will buy the horse and the nephew is okay to sell the horse. Even though the nephew had an intention to sell the horse to the uncle, he did not reply back to his uncle, and the particular horse was sold to a third party at an auction. The uncle was very unhappy and sued the auctioneer. As the nephew had not communicated the intention to accept to his uncle, there was no contract between them, and as a result, the horse was still belonged to the nephew and not to the uncle. So to conclude on the form of communication, the court is usually prepared to accept any reasonable method of communication as effective. Where there is no method specifically requested or mentioned, the methods that we have discussed in the previous slides could be applicable. So the moral of this section would be the law or the legal framework is not always a hassle, but it accepts based on a certain logic. We have now completed two components of the prerequisites of a contract, which are offer and the acceptance. Now we will be moving on to the third one, which will be consideration. So, what do you really mean by consideration? If you look at the definition, it could be a benefit to one party or a detriment to the other. And it will be the price of the promisee. So meaning when a seller wants to sell something, the buyer will be considering the value that the person or the organization will get out of this purchase, and they will consider whether they will be able to use this product or service and pay something for the seller. So the price of the promise. So the buyer will be promising the seller saying, yes, I have considered or I will be considering, and then I will pay you the price for this respective product or the service. So a promise will be done by the buyer to the seller. When you look at consideration, there are 5 basic rules that are governing this consideration, and they are: it must not be in the past, it must move from the promisee, it must be sufficient, it must not be something the promisee is already bound to, and the last one would be it must be legal. We would be discussing these 5 rules in the next few slides. Rule number 1. Consideration must not be in the past. Meaning, a promise to pay for goods or service is only enforceable if it is made before the promise is carried out and not after. So meaning, when someone is purchasing some goods or service, the buyer should promise to pay for these goods or services in advance of the purchase and not after the purchase. If it is done after the purchase, it might not be valid. I have jotted down an example in this slide. A house was left by Mr. McCuddle to his wife for life. On her death, it was to be sold and the proceeds divided between the children. The wife of one of the children paid £488 for home improvements, and on completion of the work, the children agreed that she would be repaid from the proceeds of sale. But after Mrs. McCuddle died, the agreement was disputed because the promise was done after, not before. This is a famous court case in the UK history. The second rule would be consideration must move from the promisee, meaning only the person providing the consideration can enforce the contract, meaning the promisee. The consideration should only come from the promisee. Rule number 3. Consideration must be sufficient. In simple terms, any consideration should have a certain value. So the consideration must be of any material value and it must be capable of assessing in financial terms. It can be also sufficient without being adequate, meaning it does not need to be in a full market value. In quotes, they are not interested whether the involved parties have made a good deal or a bad deal, but that something has been exchanged. Therefore, from a legal perspective, consideration can be met even if the contract is unethical. Then we move on to rule number 4. Consideration must not be something that the promisee is already bound to do. Meaning, if the promisee is bound to do something, then consideration must not be applicable. Example, I have stated down another court example. Collins was a witness in a trial and was under court order to attend. Failure to do so would have made him guilty of the crime of contempt of court. Collins' testimony was advantageous to Godfrey, who promised to pay him if he would attend this trial. And the final rule will be consideration must be legal. Any contract is only enforceable if the subject matter is legal and accepted in the legal framework. Immoral contracts are also not enforceable. And when it comes to equity, it must have clean hands. So, if your contract is immoral or illegal, it will be unenforceable and you therefore will be unable to take the matter to courts.